La table ronde s'achève sur une note.
We're ending this panel on a note which is not that optimistic in terms of whether international law can deal with the challenges of outer space. But let's remain confident. We have experts, intellectuals, thinkers. I would be inclined to encourage you to continue in this direction. Thank you very much.
La table ronde suivante nous conduit à redescendre sur Terre. Suzanne va venir immédiatement avec...
Suzanne, I would like to call on you, please, with the other panelists. In fact, a rather special Centre for Studies and Research is going to be presented now. It's an innovation here in the Academy, because when the epidemic forced us to keep our doors closed, in fact, we wanted the Centre for Studies to address an issue, the most topical issue at the time, i.e. that of epidemics and international law. And of course, as the whole world was in lockdown, we decided to undertake this research entirely online. And this experience was made possible because of the efforts carried out by two experts, a well-known, experienced expert who since then has written his memoirs, Professor Mourazet, well-known specialist in this area, and indeed another person who is at the origin of a resolution by the Institute of International Law, and then another person, a younger expert, Mrs. Suzanne Zhu. And Suzanne's main characteristic is that she, in fact, graduated and she received the Academy's diploma. People who have obtained that diploma are few and far between. And we thought to ourselves, well, to involve her in Professor Mourazet's work might be a great experience, very enriching for both, mutually enriching, age and youth together, to hold a Centre for Studies online. It was a magnificent experience, and it led to the publication of a very good book carried out or accomplished very quickly using all the modern technologies to deal with the challenge of this epidemic or pandemic. Thank you. You now have the floor.
Merci beaucoup, Professor Thévenot, and thank you everyone for being here today for the discussion on epidemics and international law. We might switch up the format a little bit because we wanted to have a little bit of an interactive dialogue between the panelists. My name's Suzanne Zhou. I work at the McCabe Center for Law and Cancer, which is an NGO that works on legal issues in global health. And in addition to being an alumni of the summer course, as we heard from Professor Thévenot, I co-directed this special edition of the Center for Studies and Research with Professor Shinya Murase, who was unfortunately not able to be here today. I have here on the panel Dr. Fernando Arletaz and Dr. Gail Lithgow. Dr. Fernando Arletaz is a professor of international law and international relations at the Defense University Center at the University of Zaragoza in Spain. And Dr. Gail Lithgow teaches and researches in international law and global governance at the University of Manchester and is currently director of the Manchester International Law Centre, although she's just about to take up a position in global law at the University of Edinburgh in July. Gail, Fernando, and I worked together for more than 1 year, but this is the first time we've met in person, so it's a delight to be here with you. I'd also like to acknowledge in the audience we have another participant from the Centre, Dr. Otto Spijkers, as well. So thank you for, there you are, Otto, hi. Thank you for being here. I'll start by just introducing some of the background to this project, and then we'll have a question and answer with our two panelists. And we'll try and open the floor to questions as soon as possible, because I'm really interested in, we all have personal experience of an epidemic in international law now, and I'm very interested in what everyone's thoughts are. So just to start by introducing the topic, this is not a new topic in international law. My co-director, Professor Morace, tells me that it had been proposed by Mr. Peter Truboff to the Curatorium in 2009 in response to the H1N1 influenza pandemic at the time. But of course, in 2020, for obvious reasons, it was a topic that became impossible to ignore. So the course was really the brainchild of Professor Morace, who in March 2020 had proposed the topics of epidemics and international law in his role at both the International Law Commission and the Institut des Droits Internationaux. The Institut des Droits Internationaux took that forward as a series of draft articles. I understand it's also still on the agenda at the International Law Commission as well. And so when the summer courses at the Academy were cancelled due to, the extraordinary situation we were in, Professor Morace proposed the idea of having this one-off online edition of the Centre based on his project with those two bodies. And to their great credit, the Academy took up the offer. I'm very grateful for them, especially because we got a special disposition to have a volume only in English, just due to the difficulties of getting together the two languages in that particular time. And at that point, I was brought on to co-direct the project as one of a very small number of people who specialized in global health before the pandemic. So the course was entirely online. I believe it was the first time that there had been an online course at the Academy, so we were very much building the boat while trying to sail it. It was a very interesting experience, which these guys took in very good spirit. 35 participants took part in the course. We had 29 who prepared chapters from the book, and as Professor Thévenot mentioned, it was put together in record time. We're very grateful to Simone Cartier and the publications team at the Academy for their assistance with this. And so I'll talk a bit about the scope of the project. It's about epidemics and international law, and you can see from the book that is available for display what a wide range of topics that covers. Everything from scientific evidence to the WHO, the international health regulations, disaster law, human rights, the Africa CDC, the Pan American Health Organization, public-private partnerships, investment law, shipping law, and it goes on. Environmental law, it goes on. So we knew from the start that we wanted to look at more than COVID, and not just to focus on the WHO legal regime, or what is known as either international or global health law, depending on who you ask. The first reason for that is because, as we all know, different subfields of international law shouldn't be looked at in isolation from each other. They interact in many different ways. And second, because when you work in health, you know that large parts of what ensures people's well-being and health are determined by things other than the medical system. In the public health jargon, we call this health in all policies, and the same in international law. Human rights, trade, the environment, security, aviation, shipping, animal law, they're all really important to the cross-border spread of disease. So we wanted to look at this from the perspective of general international law. And we also wanted to look at this from experiences broader than COVID. COVID was not the first pandemic. We hope it will be the last, but it's probably not likely that it will be. And so then we also had the question of thinking about what diseases other than COVID we wanted to look at. Are we looking at this in terms of pandemics? Are we looking at this in terms of epidemics? And if we're looking at epidemics, do we just want to look at the infectious ones? Or do we want to look at, for example, a lot of the epidemiological definitions define an epidemic by how much something is growing. That is broad enough to encompass something like, for example, heart disease as an epidemic. So what do we mean by an epidemic? And then, of course, you have a large number of infectious diseases, for example, malaria, that are endemic as well. So the question of this was, well, what do we mean by epidemics and international law? So when it came to epidemic, we decided to focus on this from the perspective of epidemic infectious diseases, and we have a number of chapters that look, in addition to, of course, COVID-19, we look at HIV, cholera, tuberculosis, Ebola, the plague, the Yersinia pestis plague, and of course COVID-19 itself. So it is epidemic infectious diseases from the perspective of general international law, covering 29 different topics in about 700 pages, and we've only just scratched the surface. As soon as we sent off the manuscript, I thought of 3 other topics we should have covered at least. And what's very challenging about this topic as well is that it's a moving target. So as a result of the COVID-19 pandemic, we have since seen a major rethink of global health governance. Since we finished the manuscript of the book, the World Health Assembly has set up a working group on amendments to the international health regulations, which were the pre-existing main treaty that regulated infectious disease threats as well as other kinds of public health emergencies. There was an intergovernmental negotiating body that negotiated a convention, agreement, or other international instrument on pandemic preparedness, prevention, and response. Again, that is only the second time the World Health Assembly has exercised its treaty-making powers. We've seen the end of the COVID public health emergency of international concern under the IHRs. Of course, that doesn't mean that COVID is gone as a public health problem, but it is no longer in that, emergency stage under the relevant international instrument, and there's a move to a longer-term strategy in response to COVID. And of course, we've also had another public health emergency of international concern in the meantime with Mpox. So it's a very interesting time to be in global health law. We're looking at some of the largest lawmaking projects in global health in the last 30 years, if not since World War II. And what we want to do today is to discuss the research from the book at that particular moment in time, but also have a discussion about where this topic has been since and where it might go. And I'm really hoping we might also be able to have a good audience discussion on this. So without taking up further time, I'll turn to our panelists. My first question for you both is would you each be able to introduce the topics of your excellent chapters that you prepared for the book? Perhaps Fernando.
Thank you. First of all, I would like to thank the Academy for the invitation. It's a pleasure to be here. In my chapter, I studied different ways in which human rights can be restricted in the context of an epidemic or pandemic. And for methodological reasons, I focused on civil rights, but I think that it's equally interesting to focus on social rights or political rights. International treaties, as you know, as you surely know, have two kinds of, or permit two kinds of restrictions to civil rights. Normal restrictions for public order, to protect public order, public morals, and so on, and extraordinary derogations in case of a public emergency. And during the pandemic, we all witnessed a huge public debate about the legitimacy of the restrictions to our civil rights. Of course, international law does not have a clear-cut answer to those concerns, to all those problems, all those ethical and philosophical problems about the legitimacy of the restrictions. International treaties have some general guidance on how civil rights can be restricted, but they use, of course, very large indeterminate legal concepts, just like proportionality or the temporary nature of restrictions, the necessity for the restriction, and so on. So these are of course, very, very indeterminate legal concepts, and we have to interpret them. We can find some guidance on how to interpret these concepts in the case law of human rights bodies like the Inter-American Court of Human Rights, the European Court of Human Rights, or the Human Rights Committee of the United Nations. When I wrote my chapter, the specific case law on epidemics was still very scarce. There were some examples about HIV, for example, but it was not very developed. Afterwards, the bigger case law, bigger corpus of case law has been developed, especially by the European Court of Human Rights. So now we have more references to rely on. Just two examples. When I wrote the chapter, I had to rely on general references about restrictions on civil rights, but there were some particular cases which had been decided by the European Court of Human Rights, which were quite useful for my research. For example, there's a case of 2005, Ehrenhorn versus Sweden, in which the European Court of Human Rights had declared that the privation of liberty of an HIV positive person was a violation of the convention. But these were isolated cases. Afterwards, the European Court of Human Rights has developed a heavier corpus of case law. And we have, for example, now a case on the particular case on the legitimacy of the lockdown in Romania, for example, and so on.
Great. Thank you, Fernando. Gail?
Yes, okay. Thanks, everyone. Thank you so much for the kind invitation to speak today, and a big thank you especially to Suzanne and Shinya Murasi for directing the centre so well through such a difficult time personally for everyone in the room. It was quite odd to work and write and research on pandemics while you were trying to maintain some kind of personal distance from what was going on around you. So I can only imagine how difficult your task was. My chapter was a little bit more removed, or at least I felt like I could deal with it, because mine was on the institutional architecture that was, and the various practices within international organizations that was set up to deal with the pandemic. And as a result of this examination of the institutional architecture that was set up, I, if you like, joined the call that Eyal Ben-Venisti first kind of made in his Hague Academy lecture to create this law of global governance, because to try and make sense of the institutional practices that takes place, and perhaps even, and I'd love to hear your perspectives on this, perhaps even replace the idea of a law of international organizations with the law of global governance. Because the efforts to try and combat COVID-19 prompted several ad hoc frameworks and institutional developments, primarily something called the Access to COVID Tools Accelerator, or ACT-A, as I will refer it to, which was launched very quickly in April 2020, which had 4 pillars. One on diagnostics, which was co-convened by the Global Fund and by the Foundation for Innovative New Diagnostics, FIND. There was a therapeutics pillar that was led by the Wellcome Trust and Unitaid. Then there was the vaccine pillar, which is perhaps the one that we were all most familiar with, called COVAX, which was convened by CEPI, Gavi, and the World Health Organization. And then there was something called a health systems connector pillar, which was to connect all 3, which was led by the World Bank and by the Global Fund, although elsewhere it was also indicated that the World Health Organization convened this systems pillar as well. And that's what was so interesting when I was doing the research on this, was how difficult it was to get very clear information as to who was convening which pillar and which activities, and how exactly what their legal relationship was to one another. And I think what allowed me, in essence, to have a little bit more distance was it was refracting many of the issues I was seeing within the law of international organizations more generally. And it's refracting a lot of broader changes in international institutions, although it has been especially prevalent, if you like, in global health, in the field of global health. And just like epidemics are not new, the interaction, or the development of institutional practices and health being linked together is not new either. Some of the earliest international organizations were actually created to deal with the cholera epidemic, and here they were playing with a lot of interesting kind of institutional practices, to the point where there was one conference where a medical expert and a state expert would have one vote each, and that was often the medical expert was then cancelling out the vote of the state that they were representing. And so it's been very much a crucible for invention. So it's a fascinating field, and it's something that I thoroughly enjoyed researching, so thank you.
Thank you both. Both very interesting chapters. We still have more questions for both Gail and Fernando. They're not off the hook yet. I guess reflecting on the experience of the last 3 years, what is one thing you would say the pandemic has changed about the area of law that you work in? Gail?
Well, potentially just as I ended, it's more that it was refracting changes that I was already seeing. And this was the other thing that I think has been interesting, to see the negotiations of the pandemic treaty, to see the reforms of the international health regulations, and also this new framework of One Health, and how we're going to realize One Health, one global health, in an institutional framework globally. And so what I again found interesting about the topic was the reason why, for example, COVAX was so successful was because it required you, when you were joining COVAX, what you were really doing was signing an agreement with Gavi, which is a public-private partnership, which of course meant that the United States didn't have to join an international organization and put through a vote to the Senate to ratify the treaty. And this is also a feature that's happening now with the negotiation of the pandemic treaty versus the content of the international health regulations, whereby increasingly the US is trying to move some content that might otherwise have been in a pandemic treaty into the IHRs, because they don't require this 2/3 Senate vote. And so you are seeing the increasing deformalization of international law and of international norms through these practices. And I think that is much broader than health, but health is an interesting field through which to see some of these issues in action.
Fernando?
Thanks. Yeah, I think that COVID reminded us of the fragility of human nature, and this had a huge impact on our conception, the way we conceive of human rights. First, I think that the pandemic showed that human rights themselves are more fragile than we usually think from a Western self-indulgent perspective. Critical legal studies, for example, have used concepts such as the liberalism of fear and securitization of health to show some authoritarian trends and that emerged during the pandemic. Of course, we don't need to use these concepts or we don't need to delve into critical legal studies to perceive how authoritarian and also democratic states have used the idea of public emergency to restrict civil liberties in a way which sometimes was not clearly legitimate. Second, I think that the pandemic showed also that the balance between rights and restrictions, and also the balance between rights themselves, is not given once and for all. It's always moving. Just an example: international standards on social rights, and the right to health is a social right, establish that states must deploy resources to their maximum ability. But to do this, states need money. And to get money, they have to restrict other civil liberties, in particular property rights. So does this mean that international law can constrain states to put in practice a particular tax system, or to introduce extraordinary taxes to big companies to get money to this? Well, I'm not sure about that, of course. And the third point is that the pandemic also showed the crucial role of some private actors. We can think of vaccine providers, for example. It is impossible to fight an epidemic without vaccines. But also, we can think of other actors out of the economic field. We can think of the role of civil society organizations providing care for all the people, children, persons with disabilities. We can think of families accommodating refugees and so on.
Great, thank you both. And I think I will make this the last question before we open up to the audience. I think one of the unique aspects of this project was how much it was evolving in real time while we were working on the chapters. And so with the benefit of 2 more years of hindsight, is there anything you wrote about what you wrote in 2021 that you would maybe rethink now?
Yes, I think that there are 2 points or 2 important issues in this regard. First, I think that more attention should have been paid, both in my chapter and in real life, to the unequal social impact of restrictive measures. Some group of people, like professors, teachers, civil servants, continue to working from their homes, getting their salaries, and so on. But other groups of people suffered a lot because of the restrictions. We can think of small businesses, people working in the informal economy, etc. And it is not only the economic impact which matters. We can think of the mental health impact, for example, of restrictive measures on older people, on people with disabilities, etc. And the second issue is also inequality, but inequality at the international level. The pandemic reinforced the differences between states with a huge medical industry and states without it. I mean, between states with easy access to international credit and states without that access. And once again, current international law does not provide clear solutions to all these problems. Concerning inequalities within states, many human rights bodies, like the Human Rights Committee or the Inter-American Commission on Human Rights, have urged states to take into account the needs of particular groups. But again, these are generally quite vague statements, and the margin of appreciation of states is still very, very broad. And concerning the second issue, inequalities among states, I think that international law and the international law of human rights is still less prepared to tackle this issue. Maybe because of its individualistic background, or because of its need to proceed on a case-by-case basis. Maybe other branches of international law, maybe branches related to international cooperation, for example, are better prepared for this.
And in terms of maybe what I would, well, I couldn't have written a different chapter at that time. It's in many ways my chapter is now legal history, because the institutions have already changed all over again. Instead of the Facilitation Council of ACTE, there's now, or there was, a monitoring task force that had 2 different working groups that were monitoring, first of all, tracking and accelerating progress, and then a financial and resource mobilization working group. And they have also ended their operation in March 2023, or their operations were due to stop in March 2023. So even if I had rewritten it and updated it, it would already be out of date. And that's what I find so fascinating and important to study about the law of global governance as opposed to the law of international organizations, where you are not studying permanent bodies and permanent organs, but often something without any kind of formal legal basis, but that has hugely important roles in our lives in terms of governing our everyday. And so I will leave it there.
Absolutely. Thank you both. Do we have questions from the audience? Peter Truoff.
2 quick footnotes and 1 question. I pushed this subject in the curatorium. I was a child of the South, and my mother worked as a dietitian in hospitals in the South when children were in iron lungs. And that stayed with me as I became an adult. Second footnote, it is true there are lots of reasons to avoid treaty making in the current political situation in the United States. But let's forget, when the treaty becomes the law of the land, supremacy principle in the United States, it is sometimes very important to have a treaty. Question, as you think about what legal principle would help to deal with the next pandemic, this is an area where the absence of transparency can cause harm. And we haven't yet developed a notion that if you have information that you are withholding from the world community, you are causing harm. This is not a case where you need to inspect to see if you're building weapons. This is a case where you need to provide information so that experts can see, how do we stop this? And we've got a great debate in my country, as you know, over where this came from and who's withholding what information. I don't want to get into that. Do we need a principle that says the absence of transparency is itself an international wrong?
Yeah, shall I? Oh, do we want to collect a few, or? Oh, Monica?
Yes, thank you. I wonder whether the panel can comment on any lessons that may have been learned from the criticisms that people like, for example, Lord Sumption in England made to the lack of effective parliamentary scrutiny of emergency COVID powers applied by different governments, whether there has been some case law or some lessons that you may be able to draw from such criticisms and challenges. Thanks.
One more?
I have a question. My question is about the difference you foresee between the current international regulations and the new treaty. The discussion was about not only of the scope of obligations, but also the way states will be more open to cooperate, and the situation of operators which are non-state operators. Thank you.
Thank you. All right, maybe I will take Peter's question, and you can take Monica's. And perhaps we can. Great. I thank you all for those great questions. I think in terms of the legal principle, and I guess more generally how to deal with, compliance issues with the existing IHRs. Of course, notification is one of the existing obligations that we have under Article 6. There's a number of proposals in the book. One of them is to have something akin to the environmental law due diligence principle when you are doing something that may lead to an epidemic. There's an obligation to undertake an impact assessment. That was a proposal made by one of the authors. I think there's also a number of, there was also a chapter, a very interesting chapter by Olha Bojenko on perhaps amending the IHRs to have more of an inspection system, drawing on some of these other treaty regimes that have either facilitative or perhaps in some cases more kind of compliance-focused inspections mechanisms. So I think there are a number of proposals in terms of how to, ensure that free information sharing. I think, politically, there's also kind of an interesting dynamic in that sometimes countries don't want to share because they feel like if they say that, for example, they found the Omicron variant in their country, they're going to get travel banned. And that's part of the dynamic with a lot of notifications as well. And so it's quite a knotty issue. There are a number of, live proposals. I have to say I don't know which of the proposals I prefer. I don't have strong opinions on which to look at the moment, but it's, certainly how to ensure implementation of the existing international health obligations is a very big issue in the different revision processes.
Well, thanks for the questions. I will try to answer all of them together. I think that there is a well-established principle of international law, which is very useful in this situation, and it is, of course, the principle of cooperation. And an important lack of transparency may amount to a violation of the principle of cooperation. I think that's clear. But I also think, and I think this is a lesson we have learned during the pandemic, that cooperation is not enough, because we need to put some content into the principle of cooperation. The principle of cooperation is a very vague, formal principle. And I think that the content to put into this principle may come from other principle, which is not a well-established principle in international law, which is the idea of solidarity, not only cooperation, but solidarity. And so this has some relation with the question about treaties. Do we really need a treaty to do this, to establish cooperation and solidarity obligations? Well, it depends. It depends on the kind of treaty we are talking about. If we are talking about a very vague treaty with only general principles and no compliance mechanism, I think it wouldn't change anything. If we are talking about other kind of treaty, a treaty with specific obligations, with some inspection mechanism, and so on, it could be different. I don't know your opinion about this.
Yes, so solidarity was going to be the key kind of principle, and I was going to pivot to Otto, who wrote the chapter on solidarity for the book, so do give it a read. And I think it's interesting to see the return of solidarity as potentially a legal principle. There's some work as well being done on this in terms of EU law and European solidarity as well. In terms of the lessons learned from the UK and the COVID contracts, I think this is one of the reasons why I wanted to understand the legal structures or the institutional structures and where the contracts were also going for the various pillars within the World Health Organization, the World Bank, Gavi, the Global Fund, the Wellcome Trust, FIND, the list goes on, because there were so many actors involved in this, and there was very little accountability that was obvious. And so we might hold states up, rightly so, to kind of determine where money was spent, and we're able to do that because of various democratic processes within the UK. And of course, what has happened is absolutely shocking. But my concern, or the concern that was in the back of my mind as I was writing this chapter, was to whom are these contracts being awarded by the World Bank, by Gavi, etc.? And there is very, very little transparency over that. And so in terms of who audits the ACT-A accelerator was a key concern of mine.
And I might take the question on the new treaty and what it might fill. So I guess the interesting thing about the international health regulations is that they look at a very kind of specific part of the pandemic prevention, preparedness, response. So you see an unusual event, you notify it, the alert goes out, you get some advice, and then what? So I think, we have a number of chapters that look at the and then what, and often it's left to, human rights law or disaster law, and that's not very comprehensively dealt with in the current IHRs. I guess where it's hard to say because the World Health Assembly is meeting this week, so I can say something now, it might be out of date tomorrow. Where the negotiations are at is looking at things like vaccine equity, looking at things like sharing genome sequences of viruses, looking at things like how to deal with misinformation, and those are the issues that have been identified as something that might be the subject of new international obligations. The other side of it is also the kind of what Gianluca Berci calls and Jorge Vinales call deep prevention, which is looking at things like One Health. So for those who don't know, One Health is combining animal health, environmental health, the health of the planet, and health of people. And it's looking at sort of that kind of preventing things at a much earlier stage. In the IHR, there is inclusion of core capacity, which is, making sure that you have a health system that is capable of detecting cases and so forth, and having being able to kind of put controls on how it spreads through border checkpoints and so forth. But there really isn't anything kind of looking at what you need to, the step back from that, where you would need to, I guess, take a more holistic approach to preventing epidemics and pandemics and viruses with pandemic potential from happening in the first place. So I guess there's not too much on strengthening the health system more generally. There's not too much on dealing with these interlinkages between the environment and human health. And certainly the animal health regime and the human health regime are quite fragmented from each other. There are cooperative elements, but I think there could be more done there. So, a question?
Thank you. So I'm not by nature a pessimistic person, but I want to ask a pessimistic question that ties, I think, together both the comment on the principle of solidarity and I agree. So in the early days of the pandemic, that really emerged both as a rhetorical matter and I think as an international law matter, as a guiding principle, perhaps, of how a response might develop. So I want to link that also to the comments about the shift from a focus on international organizations to global governance. So my impression was that all of the work that was being done, for instance, in the vaccine pillar, was actually happening parallel with much more traditional state-centric investments, right, in the development of vaccines. So, the United States stood up this huge investment in the local development of vaccines. Other countries did as well, with, I think, maybe the expected result that in the end, the investments in that sphere kind of overshadowed the ambition to contribute jointly to a global vaccine development and fund that would then lead to equitable distribution of the resulting vaccines, so that when it came time to the distribution phase, there was gross inequality, there was stockpiling, there was the desire to focus on local populations, local priorities. So I wonder, if these two systems continue to exist side by side, where we're expecting solidarity and global governance while continuing to have the more traditional modes of regulation, are we ever going to get anywhere?
Do you want to take that, Gail? I'm happy.
I think that's payback for me asking you a tricky question earlier, because and there isn't a simple answer there, I don't think. I think what was, I was writing about this from the perspective of international investment law during the pandemic, and the debates that were happening in Europe and in America was very different from what my mother-in-law was going through in Uzbekistan. And there they were having different vaccines tested out on them, and there was also the rise of misinformation about what is exactly in the Chinese vaccine. Is it actually the vaccine, or are they just putting water in your arm? And so it was interesting to see all the very different discourses that were taking place, outside of Europe and the West. As for my hope for solidarity, I'm possibly more pessimistic than you. There's something else I'm currently writing on within Europe, the pull between neoliberalism and solidarity, and there it ends up a little bit more pessimistic, but maybe Otto would be the best person to speak on this. He's waving no, but it's a genuinely excellent article. But it kind of, to me, it shows just how complicated the situation is, that you have domestic manufacture, you then have to go through the various trade regimes and TRIPS regimes, and yet we had this alternate discourse about global solidarity at the same time, and you just needed to see how badly the vaccines were arriving, for example, in Gaza without the correct conditions, and some of them got ruined because of the length of time it took to get delivery, and then how little of the world actually was vaccinated by COVAX is also quite shocking. So it's not an easy answer, and it's going to be a constant negotiation in the future, and this is why I'm so interested in this turn to global governance, to understand, not because I don't think the law of international organizations helps us. We need to understand the private actors or the unregulated private spheres and see that as entangled with other pluralist legal regimes. So this is why I think I need to turn to looking at the more Benvenisti style approach to this.
I might add to that from perspective as a practitioner. I think in May 2020, there was a brief moment where I was very hopeful about vaccine equity. I think there were a number of new initiatives that were stood up including COVAX, but also the patent pool to try and, there were all these pharmaceutical companies making statements about how it was going to be a global good. And that's, clearly not how it turned out. And I think there's a number of places where it went wrong, some of which are long-standing and some of which were pandemic-related. And I think the first of those is that there's an enormous amount of public money that goes into the development of vaccines, diagnostics, medicines, therapeutics. But there's not really a condition that in exchange for that public money that it becomes more widely distributed. So I think, and maybe this is an interesting question for the private international lawyers, there could be more done on a contractual basis in terms of linking that access and with, I guess, the public money and the subsidization of these health goods. And I think the other aspect of it, I know there have been proposals to address, for example, public funding and how you deal with the products of public funding as part of the pandemic treaty. But what's really tricky is that there's multiple forums where this takes place as well. So there's the World Trade Organization, where you have, for example, the TRIPS agreement, and that requires a certain number of years of patent protection, as well as things like data exclusivity and so forth. And there's different flexibilities in that, but they generally only are helpful if you have manufacturing capacity. And so that's one of the things about the waiver was trying to ensure that countries that had that manufacturing capacity could export to other countries that didn't, and ensure that there's that distribution more widely of those. And so I think there's that need to not only address that through the health system, but also perhaps look at I'm super pessimistic about this happening, because every time it comes up in any negotiation about any health issue, it's one of the most, toxic and contested debates. I think there's differences of opinion on how we address that issue, but everyone kind of agrees that the current system for intellectual property, drug development, research and development is not working. So there's a need to kind of look in multiple forums as to how to address that. Yeah,
just a little intervention to add a little bit of pessimism to your answer and something about global governance. I think that the pandemic was maybe the most clear example of a global problem that we tried to face with national solutions. And this was true even within the European Union. The reestablishment of border controls in the Schengen area was a clear example of states trying to protect themselves, trying to face an international global problem with national solutions.
So I think we have time. So thank you all very much. And yeah.